Today's lesson will focus on company meeting and we will look into charges as well. So basically, we have to understand information, how it's done, and how they are different kinds and how they function. Okay. So in company meeting, we are going to look into two categories. So there are two kinds of meeting. The first is directors meeting. That means board of directors meeting. If you learn like that, we have board of directors and then shareholders, other members, so we have the board of directors meeting, which is something that is very close. It's a close circle meeting because it's not the meeting of 5 people. They gather and they discuss. And the second part is the members meeting, the general meeting, right? That focuses on annual general meeting. That is, that's something that happens on a regular basis. Every year there will be an AGM and one general. Whereas extraordinary general meetings are held when there is some special circumstances arising. Can be a reason, yeah. They want to change their articles of association, or they want to make or add some value to the initial capital, like something they want to make substantial change the company's course of business. If that's the case, then they will go for an extraordinary meeting. It should be of urgent because it cannot wait till the annual general meeting. That's why they will go for an extraordinary. Right. Okay. So now let's look at the first one, like a normal. Right? Are you expected to write sections, legal provisions in your exam? Section 135. Okay. So the good thing about section is that it will help you to remember any order. That's the benefit. 103, okay, comes to 1 34, then extraordinary comes in because that's an order of the numbers and you remember the order. So just use it as a trick. You necessarily have to memorize it, but just to make, even if you make like a short note, it's easier to have the number. 133 is about this. Otherwise, it's difficult for you to organize in your mind. So here, this says that the board of directors should hold the meeting. So by this time in your first year, you learn to business law, right? Or legal environment. Okay.
Very simple.
Right. Okay. So this is the first time we are studying law subject. Okay. So I'm not sure if we had the chance to look at the other legal documents. When it comes to the law, every word matters. In some places, it will say may. Some will say should be. Some will say must be. So it has different weighting, right? So if this one says should, that means mandatory requirement. May means it's an option. You can either do it or not. So they are setting a timeline as to when this annual general meeting should happen. So tell me, what is the balance sheet date of company? 1, 4, and day before. Balance sheet. 31st March. Any other answers? 31st December, yeah. In some places, it's 31st of March. In some places, it's 31st of December, right? So it should be later than 6 months after the balance sheet date, and it should not be later than 15 months after we get annual general meeting. As I said, it happens in January. It cannot go to the next month because that will be March. So it cannot go to 8. But it will come on the 16th month. So it should be within that time frame. And it also has a requirement saying it should be within 18 months after incorporation. What's incorporation? Section of the company when it started, right? So they look into a timeline of that aspect. So this can be done by a solution in writing. That means they all can come together and decide when to have this AGM, annual general meeting. It can be done by resolution. And in addition, the registrar is also empowered to convene for the AGM if the need arises. It's a very normal procedure. Minimum, at the very minimum, they should have one AGM, right? Within this time frame. So we looked into this. So that's fine. Now let's look into extraordinary meetings. This is of importance because mostly in your exam you will be tested on, for example, giving a scenario explaining a particular scenario. For example, it can be about members, let's say shareholders, a number of people. 5 out of 10 shareholders want to change the objectives of the particular company. So then they will be asking you what kind of meetings they should go for. What's the procedure for that? How it should be done, right? Between which period it should be done. So all of this will come into when we apply it in a practical scenario. So mostly it should be in a manner where it is of serious nature, right? It can be where they want to change their objects, right? Or they want to check their registered objects. Or it can be where they want to alter their computer. It can be an event where they want to make changes to their articles of association. So all of these are of serious nature, right? If it's like small minor things, they will not go for an extraordinary meeting. Can wait till the AGM. So it will be in between 2 AGMs and other matters on a regular basis the board of directors discuss. Because some companies have like a huge number of people who are part of their company, so they wouldn't want them to come like every month or once in 3 months. That's why they take it very seriously. Only if it reaches that level of gravity and seriousness, then they will say we can go for an extraordinary meeting. They simply explains the requisition, I mean how it can be done. Okay, so take a moment to read this section 124, subsection 1. Keyword here is not less than 10%. What does it mean? 10% of it. So if there are 100 members who have voting rights, then out of those 100, 10 people should say that we should go for this meeting. Okay. This is not rocket science, it's pretty simple. It's easy to understand. Just ask. So let's imagine there are 50 members. How many people should? So that's and that they set a timeline and it should not be after 15 days and before 30 days. That's like the time frame they are setting. Not later than 15 working days and not later than 30 working days. So I don't think necessarily you have to remember like these timelines and time frame. But this is to show you that how precise the company is acting. Because at the very beginning, before codification of all of these regulations, if there is no proper system, so some companies will do it in a month, some companies will do it in 6 months. There's no proper system to organize. But these codifications the companies have made them in a proper manner which sets the model. This is like an ideal company. An ideal company would function in this manner. So that gives them some ideas as to how they can navigate any problems that they might face. Okay. If the directors, if they don't do their duty as to call for this meet, even if the 10% is achieved, then the people who are requested, like the people who have requested, can themselves convene the meeting. Because there can be instances where the rest of the shareholders would agree with the decision of the board of directors. In such occasions, the directors wouldn't want to have a meeting, but the rest will say, no, we need to have this meeting, we need to discuss, we don't agree with the way you guys are running the company. So if there are like disagreements, then they can convene it on their own. But that should be done before the end of 3 months. Okay. Right. This one shows the power that the rest of the members have. Of course, directors do have more powers, but when it comes to like these serious issues, the rest of the people also takes it in hand. They can speak up and say, okay, this is not right. We are not going to agree to everything you are saying. We need to have this meeting. Okay. Next one is notice. This is very important. So when it comes to meetings, it's not just like this and the WhatsApp, hi, all of you show up at this time, we'll meet. That's not how it works. There is a process, and it is very important that due process is followed when it comes to the meetings that are held in the company. Right? So when it comes to notice, that notice for an annual general meeting, it should be then not less than 15 days before in writing. Okay, so it's important that it is sent 15 days. Then, like, it should not be more than that. Oh, sorry, not less than 15 days. So, the meetings of EGM is extraordinary general meeting that can be considered 5 for private and 10 for other companies. You don't have to memorize 5 and etc. But just keep in mind that they set a time frame for these notices to be sent. Later, we will look into some cases where there were disagreements that came because of receiving the notices and not receiving the notices. Right? It's a meeting for a special resolution. I will not less than 15 days. Don't worry too much about the members. Okay. Who are the people that are entitled to get these notices? First, every member. Second, the person who is entitled to receive. Let's imagine there's some money. It can be, let's say, it's a big family business kind of company. They can present themselves at that point, so they will have legal representatives. So they should be informed about. And of course, the auditors and registered general should be there. Okay, all of these people should be informed. I told you that notices are important, and there were times where issues were raised regarding who received, why notices were not sent. If people don't come to the meeting or not receiving, then can we invalidate the results that came out of the meeting. All of these happen before qualification. So that's why the drafters came up with the accidental omission clause. Right? Accidental omission clause basically means if you genuinely by mistake miss out to send out notices that will not invalidate a meeting's previous. If it's a genuine accident, if it's a genuine mistake, then it will not affect. But if it's intentionally done, if it's done with the knowledge of the directors, then that's not the case. Okay. This will become more clear to you when you look at the case. Okay. So of course, quorum is like the composition of people, how many people should be there. If the article is silent, I will very weak and other in monthly. Okay. Let's look into the involvement of an external party in making a decision as to whether a company should have a meeting or not. All this time, we looked into matters where internal parties like members, shareholders, directors decide on having a meeting. But there can be occasions where the external party, board comes into play and they will say, you need to have a meeting. Let's imagine the company is going back to company. The real bad question needs to be wound up. The winding up is terminating, completing the process. So if that's the reason, if they don't have a meeting, how can it come out? In that case, court will make a note. Right? So either on its own motion, the court on its own, if it identifies such event, then it will go for a meeting. They will ask the company to have a meeting. It's like forcing them. Have this meeting, take some decisions and move ahead. Okay? Or it can be like an application. Let's say there is one director who thinks the company is not running in the right way. It needs to be fixed, it needs to be discussed and everything, but others don't agree. Then that director can apply to the court. And he can request saying that I have reasonable cause, that there is a strong reason that we should go for the meeting. Right? Or a shareholder. If let's say there's a minority shareholder, he doesn't have a lot of shares, but he personally thinks that the company is not running in the proper way. Maybe he has identified some mismanagement, or maybe he has identified some fraud behaviors, something like that. So again, such shareholders can also go. That's why you must have noticed that it is made in singular term. Even as a director, a shareholder, even that one individual has the power to go to courts and request the courts to ask. So the legal request court will then decide as it thinks. Court needs to be convinced saying, okay, this is a really strong reason to have a meeting, so they should have it. Later, the court will order as such. Such meeting will be considered as the notice should be sent to court to discover shareholders. Okay, right. So before moving to resolutions, let's look into some case studies. That is fine. Whether all of these are actual cases. Okay, so we have to think in a way how the court would solve these complications. For example, the first one is a member of committee informed chairman that she will not be able to attend committee meetings. We had generally stated that I will not be able to attend the meetings. It could be for reasons of health reasons, maybe she is traveling, something else, but that's not here. Then later, she was not informed about a particular meeting, and in that meeting, she was expelled from the club. So do you think that is legally right? Do you think the club has that power to do that? Because she has stated, saying that I will not be able to come. But without informing her, do you think they could go for expulsion? No. Okay. What else thinks it's wrong? Anyone think that it's right? They can do. So this is actually the real case of Young versus Ladies Imperial Club. Okay, this is before 45. Okay, it's an old English case. So there, the court held, right, the failure to give notice of the meeting invalidated the meeting. Even if such person has stated that I will not be able to come, that person still reserves the right to receive notice. Because that is her right to be informed. And she can make a decision to go or not. She can make the decision to attend it or not. But she has the right as a member of the club company to be informed about the meeting. Right? So here they stated that since they have failed to give a notice, that invalidated the proceeding. The decisions taken at that meeting, including expelling her, is not valid. But later, the drafters stated that this would lead to opening floodgates of a lot of cases. Right? People will say this is why we don't come, this is why we will receive, etc. etc. Maybe there can be human errors. We will include all the numbers into the system. There can be mistakes happening around. So that's why they included the whole accidental omission clause. If a particular company, in their articles of association, if they have the accidental omission clause, then they can say that it is a genuine accident, so that should not lead to invalidating the whole proceeding. But just because the accidental clause is there doesn't mean that the directors can go ahead and do it. So now we are going to look into scenarios and see whether that is an accidental omission or not. Look into the second scenario. Some members did not receive notice because their names have accidentally not been put in the list. The word itself gives the answer, right? That is an accidental omission. Okay. Look at the third one. We can look at the final course decisions together. Third one. You think that an accidental omission or not? Exactly, because they believed it, they did it with their knowledge, and it was done at their discretion. It was not an accident, it was not a mistake. They very well know, of course, we are doing this, and they did it, right? So the court held that is not an omission, but rather a upload. They will not get excused under the accidental omission clause. Is it clear? Right, so you can see first one, of course, it was accidentally not put in the machine, so they were like, okay, that's an accidental omission. Second one is not, because that was done with proper knowledge. Okay, they essentially excluded it. They knew about it and then they did it. So that will not fall into accidental omission. Agree. Now let's look into fourth one and fifth one. Out a meeting saying that they want to increase the company's nominal. What does nominal mean? The capital amount, right? They wanted to increase that, but they haven't specified how much. Okay, so that's the first scenario. Second one, it goes to a notice of resolution to make changes to the memorandum and articles of association, but they haven't mentioned what kind of changes are going to be done, what are the alterations that have to be done. So these are two scenarios. So look at the principle that emanated from these two cases. In both the cases, they stated that they were insufficient. Because the first thing is the notice should be as detailed as possible. The mere notice saying this time we are meeting is not enough. You have to be as detailed as possible. Because this is an opportunity you are giving the parties, the members to be informed. Then they can make an informed decision as to attend it or not. So imagine in the first scenario, let's say it's only like a 5% increase. One person would look at, yeah, that's not good, that's fine. I don't think I need to attend. They can make such decision. But imagine if it's a 45% increase. Then that is concern. Then he will have questions saying how can we get all of this money? How are we going to collect it? What's our generating mechanism? How are we going to pay it, etc., etc. So it has to be, of course, you have to say the place, date, time, and the nature of business should be clearly stated. Right? It should be as comprehensive as possible, giving the opportunity for the person to properly understand what this meeting is about and then make a decision to attend it or not. The second one is, of course, it's a huge matter, right, about memorandum of articles, but it can be a scenario where they want to make a minor change. Then the person member will say, yeah, that's not a serious matter, I don't have to go. But what if they want to change the type of the business? What if they want to go from like a family type of business to a proper corporate? But if they want to make a substantive change to the company, if that's the case, then that should be detailedly given in the notice. So this is basically a their right to be properly informed. Right? It makes sense now why it's important to learn about notices and meetings. You can see like not being part of a meeting can lead to a lot of problems, right? They could simply, if you're not sure, they could simply expel and say, no, you don't want to go part of it. So that should not happen. So even in this scenario, right, if he was intentionally not informed, then that will not count as an accident. Right? That's clear, right? If it's done with intention, if it's done with knowledge, then no. It has to be a genuine accident. The 5 scenarios and the cases. In your exams, if, for example, if they have given you a scenario like this, if you mention the case, you would get an extra point. Even if you couldn't remember the case, just stay in a decided case and then write the facts. If you couldn't remember the name of the case, only if that's the case. If you couldn't remember the name, just write the name. No need to write the facts and decision, right? But if you cannot recall the particular name, then it says in a decided case, a woman was expelled at a meeting where she was not informed, where she was not invited to attend. Later, regardless of whatever she has mentioned, she has the right to be informed of the meeting. So similarly, in the given scenario, X or Y person in this particular company, that person should have been informed. You can just state it as such. Okay. That's cases for you. Now it's okay. Solutions, right? So as I told you, the meetings are held to discuss important matters, and at the end of the discussion, they will come up with certain decisions. Those will become whether you pass it or not, whether we all agree with it or whether some of us agree with it. So we have to make decisions at the end of the meeting. Okay. So the first point is ordinary resolution. So have you guys ever chance to vote elections? You all are about 21. Vote your chance to vote. You know, a little bit about parliament, how they function, how they pass bills and all. Some of them may need simple majority. Things like that. Okay. So similar to that setup, even in a company, for some of the resolutions they need simple majority, and for special circumstances, the more serious the matter goes, they will expect more members to agree with such position. So ordinary resolution is simple majority. What simple majority? The percentage. Simple majority. If someone says 51, right? Simple majority is 51. Remember that. I don't think you will be expected to remember the dates and all, so that's fine. And special resolution that requires 75. That comes where special resolution comes, that comes when we need our extraordinary meetings and we go for a special one where we make changes to the objectives or we make changes to the company's nominal, right? So the company can be changed. So when we make some serious changes to the company, we will go for special resolution. Right? So it should be held like less than 15 days, etc. And that's fine. However, there is an additional layer of protection that's given. If the company within the Articles of Association have already agreed that they should go for 85%, then that's also possible. So as I mentioned earlier, Companies Act, the purpose of Companies Act is to set minimum standards for all the companies. So if you want to go for another layer of protection, if you want to go for additional protection, you can go within the scope of the Companies Act. Nothing will stop. But you have to meet the bare minimum standard. Right? Again, like the number of days related. But if it's difficult to communicate such matters through email, if you couldn't contact that person personally, if there is issue with reaching out to that person, then you can go for a announcement and make sure that that reaches as much people as possible. Okay. Really? No sleep. Okay, I'll give you a like 10 minutes break on board after this. Anyway, I know like attention span is 40 minutes, used to be 40 minutes, but after reels, TikToks and everything, I think it's like 10 seconds, 20 seconds. I'm not really sure. So yeah, we'll finish resolution, we'll bring the meeting, we'll finish resolution, take a short break. And then we'll go through. So written resolution, as I said earlier, in a meeting, company meetings, people will talk a lot of things, right? X, Y, Z, they will agree. Some people say agree with X and Z, but not Y. So many discussions will happen, right? But only when it comes to a written form, things will become properly documented. Right? So it's very important that after the discussion, they write everything down and then get the signature of the people. Because some would think, yeah, this is what I agreed to, but later when they look into the written one, they're like, no. Because there can be mistakes, because when you discuss, like it's not, I mean, you can imagine, we are all humans. There can be instances where people get pissed, right? They will start arguing, they will start talking over each other, there can be a lot of things happening. So it could be difficult to concentrate and go one by one. Of course, the intention would have been to go for a structured discussion, but there can be occasions where the system changes, they want to discuss different things, maybe they will have like an agenda, but later they will like, no, this is important, let's discuss this, and it can make a lot messy. So in those instances, it's very important that the decision, the final decision should be made in writing, and that should be signed by not less than 85% of the shareholders, making sure that they all understood it properly and agreed to the terms. Because later they cannot come and say, you know, I said this, I didn't agree to this. That's very important why we make them into writing. Right? Right. So adjourn meeting means that once, as I told you, as far as how much it's important to give notice to a meeting, once the notice comes to a conclusion, whatever decisions have been made at the meeting should be again informed to the members, the people who are present there and people who are not present there. Because it's all about proper communication and information shared. Because that's important. Otherwise, there can be a break of discussions, break of communication, and that will lead to a lot of confusions and disagreements and a lack of format. We'll look into voting and then vote. Voting won't take much time and for the break. So there are two different kinds of voting. One, strong hands, and the second one is going to a polling station and you put the votes. What's the key difference between these two methods? What do you think? It's like the main difference. Of course, result, I mean, in both occasions, the result would be same, right? Because, so if I ask all of you, right now, whether you want which selection now or to like me, all of you will show of hands, right? I think here you will have 100%, but I'm not going to answer the question. But let's imagine, let's say, I say, we all get chocolate ice cream. So half of the class, or maybe more than that, will say yes, and others who like strawberry or vanilla wouldn't. So there will be a show of hands. The same thing if I put a box here and if I ask you to write strawberry, vanilla, or chocolate and put it, the result would be same. But what will be different? Evidence, clause. So what's like the key difference between these two mechanisms? Secret voting. So that's confidentiality, right? In shorthand, you know who said what, who supports which idea. Confidentiality is the key difference. Okay? So in companies, of course, they will have a professional relationship and they will also have a friendly relationship outside of that professional environment. So in some occasion, they will have to make some difficult decisions. So they will want to hurt each other's feelings and take sides and bring some fights or some kinds of arrangements between the people. So they go for confidential voting. That's polling, right? So when they go for that, at the end, a decision will come out, but they will not know who supported the idea and not. Right? So that's why a clause is created in the company that saying, of course, now you know why. Why people would demand for polling? Because of the confidentiality, right? And who can demand it? First, it should be either not less than 5 members. Minimum at least 5 members should say we should go for it. Of course, as I asked earlier, in the chocolate ice cream scenario, I don't think anyone would say we should go for a confidential polling because that's not going to affect each other's wishes. But let's say out of all of you, 2 people want to become a student leader or whatever, and then that's a question. Some people would say he's a good friend of mine, but I don't think he will be a good leader. So then that's a problem. When it goes for show of hands, right? The friend that you can support. But if it's a polling, then that person wouldn't know, right? So it can either be not less than 5 members in the company or not less than 1/10. Again, 10%. The total position. Okay. So now I hope that you understand the difference between these two and why people would demand for. Sorry, one more on this. Yeah. So proxies, right? Have you heard of proxies before? See server proxies. Right. So proxy basically means instead of you, your friend signing for you in the attendance sheet. Do you guys do that? Okay. Then believe you all, but that's not proxy. Someone else doing your job. But here it's legal, but if you do, that's for fraud. So please don't do that. If you sign for someone else, that's fraudulent. And you can, it's like properly wrong. Why we say you should not do that in attendance sheet? Because later when you go and end up becoming an auditor in a company, you will do that. Or your friend will do that to an actual company. Okay. So proxies is basically if a person couldn't come up for a meeting, they couldn't show up for a meeting, then they could ask someone else to have their representation. So they can speak up for them, they can vote for them, right? They can do everything as if that person is present there. So that's what proxy is about. Yeah. So before going to the next one, do you have any questions? Questions on meetings, resolutions, notices? No? Everything clear? Good. Then I'll give you a 10-minute break. I mean 10 minutes, it's actually 10 minutes. And we will start at 4. Oh, sorry. 2. Did anyone get? 19, 18, 15, 16, 16. Okay. It's an open book test, right? You all know that, right? You refer like your notes and word. You couldn't find the right answer. Okay, let's see. But let's
Operation.
let's start a mix of them.
So we started.
At the end of the day, it's an open book test, right? You can go to the find the answer. Because in the previous one, yeah, 20 hours. Anyway, let's see. Okay. But let me know. Who right? Can you read this? First one, any issues? The document that outlines the company's purpose and key information. All got it right? Yeah. Any issues with the first one? No? Right. Next one. Spark Limited is a private limited company limited by shares. It has 14 shareholders. Is something about the quiz or something else? If something else, you can go outside, discuss, and then come back. It's completely fine. You are at a store. I'm going to treat you like school kids. So if you have something important to discuss, you can go outside. Fine. Okay. So it's a private limited company. It has 43 shareholders. One shareholder was given a contract of employment as CEO. How many more shareholders does the law permit it to maintain? Got it right? Or doubtful, wrong? What happened? Right. You have to tell me. As to why. If it's a doubt, then you have to tell me why.
You is the public shower of the CEO.
Yeah.
So it's continuing.
What's the limitation usually? Okay.
So it will be continuing as a director. It's a shower.
Does it say direct?
CEO.
What's the difference between a CEO and a have you finished learning directives? Duties of directives. Do you know it's CEO is different from director? Yes. Okay. How different? Yeah. What else do we know about the CEO? An appointed position, yes, correct. Okay, now let's look into a real life example. Do you all know Sundar Pichai? Who is Sundar Pichai? Yeah, so does he have shares? No. He's only getting salary. What about Elon Musk? They have shares or are they appointed employees? So, like directly, if you couldn't find an answer, then you have to go for real examples, right? So now it's an open book. So you have to tell me. You have to find about Sundar Pichai. You have to find about Elon Musk and tell me. Because for an open book test, I can't do for explanation and discussion. I can only give you pointers. So you have to find the answers. That's the purpose of open book. And this is like the simplest way of having an open book. Usually they give like very lengthy problem questions to solve for open book test because you have all the resources. Okay? So you have in the next class, the last week, you have to tell me about Elon Musk and Sundar Pichai. Whether they are CEOs or they appointed ones, whether they have shares, or if you can come up with any other real life examples. Okay. Because that's how you learn about things and that will remember. That will retain in your memory. If you just memorize X, Y, Z, X, Y, Z, that's not going to work, right? Because at the end of the day, you're all going to move to the real world and work. It will always be a good habit to look into the real world for examples and scenarios to relate. Okay. Or if you could come up with an example from Sri Lanka, that would be even good. Okay. Third one, which of the following is not a requirement for a company incorporation in Sri Lanka? Did you learn this company? So you all got it right, I guess. Yes? Okay. Costs of forming a company. That's very easy from the previous question. I hope you all got it right. Yeah, incorporation. Share in a private company. There's a confusion on this one. Previous class on this one. Any issues with this? Yeah. Because you guys know better about this than me, right? You learn about companies, private companies, and all, right? In separate lessons in length. So tell me, is this correct or? Yeah. Speaker instance, there can be conditions attached to it. Yeah.
Is it really transferable?
So that's the thing. So I think the issue is here choosing the most appropriate answer. Maybe like freely is not the best word to use here, but comparatively out of these answers, of course, C is not there. That's clear, no? So then the problem would have been whether the answer is A or B. So is it restricted or not? In general. So what's the difference between private and public? Where you get more autonomy and independence? Huh?
Yes, an issue. Private companies that can.
Okay.
No.
Even fine. Okay. So when you learn about the features of private companies and publics, how do you differentiate them when it comes to issuing shares and like transferring shares and all? How do we differentiate those?
Public companies.
Sorry?
Public companies.
Yeah.
Private
That
is
picture is
not.
fine. Yeah.
Question is the private company. The trade transferable can be say like, then we can't issue shares to private company.
So
There's a restriction.
right. So you are talking about freely transfer to anyone. Right. So I think the way the question is drafted, it is not restricted as in the like within the company it is freely transferable. So maybe we should have made it a bit more detailed. I think the answer. Right. So that's what it meant here. But restricted in transfer. So you meant restricted as in the boundary within the. Okay, it makes sense. But initially, I think when Sir drafted this question, I think he came up with a way of thinking of how it is transferable, easily transferable within that boundary. I will double check with Sir, and if Sir thinks we can give for both, then I will ask Sir so they can change that only the system. Is that the same concern for you all? So I will ask Sir that.
What about the second question?
Second question. That's something you have to tell me. If I tell all the answers. Okay, and now I'm pretty sure everyone got the sixth one correct. Yeah? This one. What's the answer? Seventh one. The answer. Both? Yeah. So even if A and B is not there, you can either go for both are correct, right? And the other one is none of the above means both are incorrect, or either one is the answer. Is that clear to you all when you are doing? Is it the same with you guys, or was it confusing? So I said, regardless of A and B, it can both are correct, both are incorrect. It means none of the above. I asked you to consider it as such. None of the above means like not all, but those two, and this two separate answers. Is that clear now, or still confusing?
Yeah.
So yours didn't show which number of questions you got right. No? Not even those green boxes show it. So I will check that, but I'm pretty sure it must have given correct answer to both A and B. That means both answers are correct. If you have chosen that option, you have gotten the marks. Right? I will check that, but I'm sure that's all. Yeah, no, that's wrong. The answer is wrong, right? Because both of those answers are correct. That's why I told you to consider it as both are correct. None of the above to consider as both are incorrect. Because I think sir didn't consider about this fact that will happen. All right. Two students left the class, or they are not coming. Anyway. Okay. 8-1, again easy. So means single. Okay, that's easy. 9. You all know about alternative dispute resolution, right? Yeah. Boys, you can not say yes. If you don't know, just check. If you don't know about alternative dispute resolution, just tell me. If you don't know, just tell me don't know. So I can discuss that. Do you guys not know about alternative dispute resolution? How come the girls know and the boys don't? I don't understand. It's like if in a classroom or class, understand how to say discuss it. Do you all know about alternative dispute resolution? It's okay, it's fine to say no. Okay, so alternative dispute resolution is basically alternative to court settlement. Right? So court settlement is our traditional way of resolving a dispute. Basically, we go to a court and we get right or wrong. Some person has made a mistake, other one gets the compensation or whatever. That's how it works now. Alternate to this system, we have come up with different other mechanisms. So it's negotiation. You bring the parties and negotiate. Mediation. You bring a neutral third party and mediate between those two. You have ever heard of this before? No, that's the question. Or did you just we don't know? No, it's an open system, so you can just say I probably don't know. Yeah. But looks like the rest of the class is like clueless as to what's alternative dispute resolution is. Because I mean, they have learned legal environment, they would have introduced you different methods of resolving disputes, and court settlement is fun. But then you have these other options where you in a friendly manner resolve disputes. So you all got that wrong, or did you all select all of the above? Huh? You have no clue about alternative dispute resolution. I have a whole top so yeah. So did you Google it?
So you got the correct answer. Very good.
So now you got the explanation. Now is it clear? So we usually go traditional method is post settlement. Anything alternative to that to resolve the disputes, alternative mechanisms can be mediation. Because in commercial setting, it's very important because imagine taking a company dispute to a courts, right? The commercial courts and all, they take sometimes 10 years, 15 years to finish a case. But if you take it to an arbitration or a mediation, it can finish up in 3 months or 6 months. Right? That's the reason. Like it's an efficient way, and it's not about actually finding fault, who is right or wrong, but it's about actually amicably resolving the dispute. Okay, so that's alternative dispute resolution. Right. Definition of prospectus. Again, I think companies that could have given you the right answer. No issues with that, right? That's pretty straightforward one. Perpetual succession. Again, Google would have given you the right answer. But is it something that you're familiar with? Did you learn about this? Long-standing company? Okay. Well, incorporation offers limited liability. You learned about this, right? So I'm sure that's clear to you because this is a very theoretical question. You must have learned it as a feature of Indian company, and now it's a question, right? Yeah. See also? Shareholders first line. Sorry.
It's a procedure of the answering. Okay.
Yeah. That's actually. How do you answer C here? And I think I'll have to check with sir because sir sent the scheme to me, so I'll have to go with that. But if it's something to be changed in the system, I'll have to talk with sir. That's wondering whether the technical term that's used to say protected. See. Any issues with 13? Yeah. Right, it's a company member and then anyone who deals with the members and company. That's clear now? Number 14. Gives out the term incorporated, so that's again straightforward. Names of the company. You studied that, right? Names of the company. Any issues with this? Anyone? Yeah. Which one did you select? Let's see. Okay, according to the the following. Yes. Okay.
And what about the
Sorry? What's like D? Can I have a look at the company? Compensation assigns it is in a way expressed by yeah. So, I mean, if you choose a common word that is used in single formula, you have those who have selected the answers. Like, let's say, being rejected. Yeah, okay. So which one did you choose? Then, so you are sure that they will not reject because it's common. Yeah. Okay, Thomas, give the answer offensive language. No one picked offensive language. Okay. A couple of you. Right, okay. So let's read the question again. Right. According to Sri Lankan company law, there are generally no restrictions on the name. However, there are some exceptions. Which of the following is not a reason why a company name might be rejected? All right. So I think the common name is something that is largely imported. Example for because for me, I think it should be actually both. Anyway, I don't think so. One problem is if you go to a register and if you just go by the words of this, I don't think they will say offensive brand. So then the question comes offensive to who? Is it to a particular community? Is it to a particular people who speak a particular language? And because there are like words, offensive words, they have a different slangs. That's something that's okay to be spoken within a friend's group, but it's not okay to be goes outside. So then the question is, it's open to interpretation. Again, same thing. What is common word in the Tamil language? For example, from oh, you thought no, it says specifically Srilanka Tamil language.
Is it
Is that a common word that is used in the language? I mean, what they in common is, of course, I can't give an example, but let's say for what's the word for sun or something? Do you know? Yeah, but that's English. That's why I'm asking. Are there like companies that have names in Sinhala or Tamil? Any Sinhala name? So the common word, that's a name, right? I think what they mean by common is like moon, light. That's my understanding. Yeah. Sorry? Yeah, that's right. I'm not sure like which answer drafted this question, but I'm asking like, do you know any companies having a singular name as a company? Not like name, like not like Pereira, but any companies having. Sorry? That's English. Louder? Yeah. But Expo is English, right? It says, yeah, Talapa. That's anyway not ours, but that's Indian, so let's leave it how they live. Is it a common word that is used? That's what I'm asking. Is it a common word that is colloquially used? Yeah. Is there a complex name? Like yeah, it is named as Surya, but private name is also honestly, I don't find it anything. I can't think of a single because I think we have got English names.
Private content.
Are they all answers? Again, offensive is something that's interpretation. So, for example, you can't like in singular version, though you can someone in a people they can say that. But then you can have a pet shop in that name, right? Puppies, whatever. Then it's a question whether it's offensive or not, because some people will use that to saying that this particular community is like this animal kind of, I have seen memes and all. Then the question is whether it's a company. Okay, so that's actually a homework for me. I'll have a look at that. I'll try to actually come up with some examples there, real examples. I think when I say common word, it means something that is colloquially used, like in discussion. That's my understanding, but I will double check this as well. Okay. Okay. 16. That's fine. That's a technical question. 17. Any issues? 17. Any issues? 17. All right. Sorry, any issues with 17? No? Okay. Again, that's technical fine. 18 is again, I think. Issues with 18? Right? Yes or no? It's fine. Sure. I think someone had an issue. Yeah? Or is it fine? 18? I thought someone had an issue with 18. You all got it right. Okay. You guys? Yeah? Is it clear? Is it like a straightforward, clear answer or you had issues?
I think the floating charge.
Sorry? Floating charges. You still haven't learned that. We will learn about it now, right? So we will look into that. So here you understood members cannot transfer their shares freely to others in the sense of outsiders, right? Freely transfer. Yeah, that's what you understood, like others and outside. Okay. I think that's the conclusion to the previous question. Freely transfer to whom? That's the question. Because within the system, it's easier to transfer. But outside, it's difficult. Right, okay.
Changing membership doesn't cover the existing.
Which one?
And changing membership has.
Yeah, changing membership has to alter its existence. Yeah.
So it's a one child in a private company.
One member private company that we are talking about. This is, I'm assuming that I don't think they will go for that when you get example of one member company.
So it's a guarantee company, so it's.
Okay, right? No, are you sure? All the other features comes to currency? No. I will check and see the difference. And one more thing. My goodness, I only have 15 more minutes. There is a difference. You have to find it. Tell me before. Okay. I think that's pretty straightforward. I don't think that's correct, but you'll have to find it. And tell me, okay? There is a difference. You have to tell me. There are, I think, 5 different components are given. Try and see whether that fits into current company, okay? Right. Which one? I'm so sorry, I have a quick lesson to finish. I have to finish that today. Okay. Community interest company. Do you know what community interest is? Community interest is like when you go and not for a profit making purpose, but rather in the interest of the public. Because you can't go for shares and all, no one's gonna invest in you, right? That's clear, right? Because no one's gonna invest in you because you're merely not going to make profit because your aim is not profit making, but actually helping, right? Of course, not a partnership, right? And the most appropriate one is the open one. It can be a public guarantee one or it can be a private guarantee one. Again, problem or yeah, then the question is, do you think a private company would want to act in the best interest of the community? Just a private company. Yeah, they can, but is it mandatory? Private, the intention is profit making, right? It has one correct and one wrong answer. Like a private company, that's intention is profit making, right? So that itself is qualified the answer. Because first one can be private or public, right? But the second one cannot be because it has one part public. If it's partly wrong, it's wrong. That's clear. We're saying a private company can be in the interest of community. You think so? Someone will invest in helping a private limited itself is to make profit and to protect yourself, right? Not to isn't it? That's the nature of the whole private sector. That's why we have private, public sector, and there's a non-government sector, and then the plus whatever sectors, right? Isn't it? Is that still confusing to you, or you're clear on that? Which one? The world bank? That's not, you mean non-government project, they fund projects. That's what you meant.
Most of the private companies also they
Fund, right? It's different between a company solely being created to act in community interest as opposed to a company funding a good thing. You see the difference? That's definitely something they do for publicity, right? They do for children, say whatever, they do that for publicity. But it's different from funding than creating a sole private company to community interest. Can you see the difference? Funding is different from having a company for that purpose. The objective itself should not be profit making. That's not the case in private company. Right, okay. And last one, of course, the company will not be the government, right? That's false. Any problem with that? Any problem with the last one? The company will be government? No, right? I hope that's clear. Okay. So I think I will, yes. Problem with that? Or if you're just trying to drag, okay. The name I will double check. You will have to, and you have to check on the guarantee company and private. And rest of you all have to check on Elon Musk and Sundar Pichai and let me know. Okay. All right. Anyway, you all came late for the lecture, so I will take a bit. So records, we will separately study as accounting records. So I will quickly look into charges. Okay. Right. So we looked into different components of companies, and charges is again one that makes it accountable for everything it does. Okay. So we are going to look into two different kinds. One is fixed charges and the second one is floating charges. Right? You don't have to get too technical with these. So basically fixed charges is something that is contained and definite. That is fixed for a property. Okay? As opposed to floating, that is not particularly focused or given to a particular holder. Not like one particular holder is responsible for that. Okay. So floating charges include movable shackles, book debts, uncalled capitals, all of these which are not definite. They are not clearly ascertained. These are technical terms that you learned, right, in accounting? Yeah? Previous class said yes, yeah. Silent, I'm not sure. Okay. So floating charges is present, future, because there is no clear boundary as to this is what it is. Right? So that's why fixed charges differ from floating charges. Basically, it's like it's floating, like you can't put it into like a box and say this is it. Right? It keeps changing. Okay? But there are occasions where you could change floating charges into fixed charges. Right? So that's the process called crystallization. So in normal terms, crystallization means whenever you change the liquid into solid state, that's crystallizing. That means you make it definite. You put a fixed. So at the liquid state, we have all these floating charges, but then we make them into a solid definite form. So this can be done when you appoint a receiver. You fix someone, a holder. When you fix someone to take responsibility for it. Okay? And it can happen when you wind up the company. Do you know what winding up is? That's bringing a company to an end, right? So at that point, you can't leave things floating. You have to fix everything and you have to finish off the business. So you will assign that to different members. Okay, this is how we want to divide everything and finish this off. Okay, and then in any other manner, when you try to dispose your company, so disposal you deal with, you change the nature of the company, you merge with another company, you amalgamate with another company. Whenever you make those changes, you have to assign things. Otherwise, they will be floating. You can't proceed further. Next one, when the company ceases to carry business. Tell me an occasion when a company ceases. What is the difference between ceasing and winding up? Good. Brilliant. That's the word, right? It's a temporary arrangement. And now tell me, what could cause such temporary arrangement? These things. Right? Brilliant. Yes. One is where a third party, like the government, they seize your business for illegal purposes if you run something. But other reasons would bring your company to a pause. Okay, yeah, that includes government's intervention buttons. Do you think the companies that couldn't do manufacturing, whatever supply during COVID, would be categorized as C? Or how do you categorize? Do we have an intelligence for that? That happens outside the control of the members as well as the government. That also comes to a post. Okay. And then any other instruments. That means if they have categorized any other means should be changed in such manner in the articles of association. So this is like an open clause that is included in a manner saying anything else. So usually in legal terms, they have this say, earlier also we looked into where 4 things first. Those ones are included in a way to open to interpretation. And earlier we looked into another clause, accident, omission clause. And in some contracts, there are exemption clause. Even if all of this happens, I will be excluded from any liability. This is something you can see in construction. You will study contract law, right? Missing out the base is a bit difficult for you to cover. Anyway, so these are clauses where they make it in a way saying X, Y, Z should be changed as a fixture, should be crystallized at this event. Right? So that is open for the companies to decide. These are a couple of occasions where it could happen, and in addition, they can have their own set of occasions. Then, also we looked into this, that's fine. Registration of charges, that means whatever charges that is counted in the company that should be sent to the registrar companies. Because all the documentations must be properly maintained. Right? That's the responsibility of the company to making sure that all of these are properly documented and sent. Right? So when we talk about this is of course like what should be sent to the registrars. It's a long list. You don't have to memorize it. But when we talk about private institutes like sole proprietorship, partnerships, and when you talk about company, we often say that it is complicated but secure. So what brings up the element? Complicated in the sense there are so many procedures to be followed, but there are equally so much accountability, not only within the company, but also from the outsiders. That's what makes it more solid as opposed to a small shop or partnership. Okay. Right. So the next one we'll talk about consequences. What if they don't properly register the charges? What's the consequences? What will happen if you fail to do so? First thing is it's an offense, right? It's a punishable offense. And secondly, the unregistered charges, whatever you have not properly registered or documented, will not be. So if let's imagine that you have given, so let's take a small shop in your village, right? So in your shop, they will, I'm not sure if anyone, are you all from Colombo, like city? All city kids? Yeah? Okay. So at least it's from me, in my village, there are shops where they have like small exercise book. And for an entire month, they will do all the purchases and record in that. And only when they get like salary, they will go and give it. So that's a very small mechanism that happens within the system. They don't really have like a system to record all of that. And that happens on a credit basis. But there is no proper registration of charges or proper maintenance of charges. But in a company, You cannot do that. If you do that, if you don't properly maintain those charges, if you don't register them, what will happen? They will come and say, you cannot claim it from us. So that's the difference you can see from like fundamentally how these charges make a difference in a small scale shop to a company. Have you ever seen such practice? Like people say, like, we will pay by the end of the month. For the whole month, they will do the purchases, grocery purchases, etc. And then they will pay at the end. Okay? Right. But in companies, if you do so, you have to properly register every single charges that you maintain and need to have proper documentations for each and every one, every single of them. Okay? Right. So that's all for today. And you all have signed the sheet, right? So can we assume that you all signed for your own names and not for others? Yeah? There. Anyone who's not in the class now? Yes. That's informal, like, right? Do they usually do a head count and check your attendance? They just trust you. You all are people with good moral values who will never cheat the system. That's all. Yeah, I'm not gonna inspect or do anything, but please don't do that. So now I have to check and see and stuff. That's like. But next week I will do the check. Please don't create an awkward situation where I have to do the check. Please don't do that. If they couldn't come, if they have a very reasonable reason, they can come. If you learn these things from here, it's not going to be easy for you to change it. Like once I become a accountant, once I become an auditor, I will not do it. Once you get used to doing it, it will just become a practice. All right, then. See you and listen.